Right. Problems.
Chat.
Yeah.
Yeah, test it. Through this, your mind.
Testing 1, 2, 3, 4. That's pretty good here, right? So that's the test. These bars.
No,
Okay.
this is the internet.
Hi everybody, and welcome back. I hope you're feeling good. All right, had a good day. Well, it's about to get much better, of course. We shall be reviewing the vitiating elements first, and I'll review misrepresentation very briefly once more, and then we'll review duress quickly, and then undue influence we'll spend a little bit more time on today, and then we'll finish off with unconscionability. Also, of course, illegality we'll cover, but you notice illegality is in block, in block, not block letters, it's in, well, anyway, not that important. That's why I put it in square brackets, okay? All right, so today's a big day. Just in case you don't know how big a day it is, today's Indian National Day. Oh my goodness, how exciting. So well done. Congratulations to all Indian people out there. It's your National Day. Also, by the way, it's Australia Day, okay? Controversially still, but it's still Australia Day. Oh, and by the way, everybody, it's my grandson George's birthday. Isn't that lovely? He's 9 today. And guess what? It's also my birthday. Well, isn't that lovely? What a nice way to spend the evening on my birthday talking to you. On I've only got one laptop today. In the other classrooms, I have 2, so I hope everything goes well as far as presentation is concerned. I'm not using a microphone tonight. I'm just speaking directly into the computer, but I think the sound's all right. I've had a very good assistance from Kevin. Kevin's a really bit of a whiz here. He sort of presses buttons and things all happen. Okay, so enough about that. Important day. Well, let's get down to business, and thank you very much for your birthday greetings. Yes. How old am I? Well, I'm 17 in reverse, if you know what I mean. Oh my goodness. Okay, so let's have a quick look at the vitiating elements, and of course must know definitions here of misrepresentation. Okay, so we'll go through that again, which of course you all know. A false statement of fact made by a party to a contract which induces the representee to enter into a contract with the representor. Okay, now there's quite a bit of detail with regard to misrepresentation and indeed some of the other topics. So this is where your definitions are so important, because these are the bedrock of your knowledge of these particular areas of law. Okay, so make sure you know the definition, make sure you understand what it means, and remember 50% of the marks on misrep are in the definition of misrepresentation. So obviously it has to be a false statement. Is it a statement of fact or opinion? You know the test. Well, very quickly we can look at it. It depends on the state of knowledge of the parties. If they have equal knowledge or expertise, a statement by one will be treated as a statement of opinion. If you like, you know, your opinion's good as mine. However, if one party has expert or special knowledge and the other party doesn't, a knowledge by the party with the expert knowledge will be treated as a statement of fact. So in Smith and Landon House, the existing owner of the property knew the existing tenant. The new owner, because the property was being sold, had no idea what the tenant was all alike. And the existing landlord said he's a most desirable tenant. Turned out he wasn't. So that was a false statement of fact. And it was indeed a statement of fact because the new owner didn't know that tenant at all. So 2 good cases on that. And of course, the representee has to be induced. Okay, Edgington Fitzmaurice, probably the most important case, because the representee has to only show that the representation was just one reason for entering into the contract. He may have had other reasons. Okay, and the courts are usually fairly lenient on a representee who's trying to prove he was induced, as shown in Redgrave and Hurd, because the representee was shown the books of account. It didn't check the accuracy of the statement made about how much the practice was worth, and the court said you are not obliged to check the accuracy of the statement. Okay, seems a bit careless, if you like, but Redgrave and Hurd's, I think, a useful case to remember. Has come up in past exam questions, Redgrave and Hurd, so watch out for that. And Edgington Fitzmaurice. So I think they're the 2 most important cases when it comes to this element of being induced. And of course, the representee has to prove all the elements. They also have to state what type of misrep they are claiming. And you know there are three types of misrepresentation: fraudulent or dishonest misrep, negligent misrep, and innocent misrep. And remember, the first two are also torts. So at common law, and when I say common law, that means no legislation, like case law, you could get a remedy in tort law for both fraudulent and negligent misrepresentation. But you couldn't get any remedy pretty well for innocent misrep. Okay. And so the law was thought to be lacking, and so it was changed in the form of the Misrepresentation Ordinance, and the Misrepresentation Ordinance has changed the law quite a lot, so that you would advise your clients that when they are claiming misrepresentation, that they, here I'm coming up to it, always claim negligent misrep. This is the must-know PowerPoint. So 50% of your marks, is there actually a misrepresentation? The representee has to prove all of the elements of misrepresentation, also has to state what type they are claiming, and you always advise them to claim negligent misrep. Okay, and you know why. Three big reasons. The burden of proof is reversed, put on the representor because of the wording, he proves. And remember section 3 sub 1 on page 106. Make sure you read that section 3 sub 1. Highlight the words he proves. In the context of section 3.1, he is the representor. So that's a big help for the representee. Secondly, it is a very heavy burden of proof, as shown by the Court of Appeal decision in Howard, Marine and Ogden, where reliance on the Lloyd's Register of Shipping was not sufficient to show that the representor was not negligent. Okay? And then last and most controversially, the level of damages is the same as for fraudulent misrep. And that seems very unfair because you're treating somebody who's merely negligent, careless, as if they are dishonest, the so-called fiction of fraud. But that's the finding of the English case Roy Scott Robertson and the Hong Kong case of Pepsi Cola, in which the court said, well, let's have a look at the wording of section 3 sub 1, and focusing on those two words, so liable, they said, well, you'll be able to claim the same damages as if the representation was fraudulent. And we haven't got onto remedies yet, but the main remedy for misrepresentation will be damages. You could also get a remedy of rescission. Remember, rescission is where the court can put the parties back in the position before the misrepresentation was made. But there are lots of limits on rescission, bars to rescission, such as undue lapse of time, affirmation by the representee, and also where the subject matter has been passed on to a third party, and that cannot be undone. And under the legislation, even if rescission is still available, the court has a discretion to award damages in place of rescission, in lieu, L-I-E-U, of rescission. Okay, so the main remedy is going to be damages. The question is, well, how much money will I get? $1, $2, $1 million? So quantum of damages, obviously very important in practice. Okay, and the measure of damages for fraudulent misrep is much more generous than under negligent misrep. Okay, the wording's a bit vague. The court's saying, well, you can claim all the damages that flow directly from the misrep for fraudulent misrep, whereas at common law, whereas with negligent misrep, before the legislation, you could only claim damages which were reasonably foreseeable. Okay, and so watch out for this PowerPoint, 40 marks, which gives you what, total of 90 marks. The other 10 marks might be, well, what happens if the representor is able to prove he's not negligent and he's innocent? Can the representee still claim damages? Yes, you can, under section 3 sub 2. And it's a lower level of damages. Okay, and then we have this slightly tricky point. I mean, if you can cover this in the exam, well done. What happens if rescission is barred? Can the court still award damages? Well, Thomas Witter said, yes, you can still get damages, but the other two cases, floods of Queens Ferry, British Aerospace, say, no, you cannot. Okay, good. Well, I'm glad the sound is back to normal. All right. So this is revisions. That's misrep. Mistake, should know, not must know. No need to go through this. A mistake is very few cases on mistake. Of course, the mistake has to be what we call an operative mistake. And if it is proven, the contract is rendered automatically void, V-O-I-D. Okay, so watch out for that. It's a very drastic remedy, and so the courts are very reluctant to find an operative mistake because it will render the contract void from the very beginning, void ab initio. Okay, we should note there are three different types of mistake. Okay, the most common one in practice and the most interesting one is unilateral mistake, where one party is aware of the other party's mistake and tries to take advantage of it. Okay, and don't worry about that. And the interesting case would be the rogue cases where somebody is saying that they are somebody they're not. In other words, mistaken identity. And how does the court handle mistaken identity cases? Well, they will say if you're dealing face to face with somebody, then identity is not an issue. You are presumed to want to deal with the person who's standing right in front of you. Okay. However, if you're dealing at arm's length, somebody at arm's length, that could be different, and so identity could be an issue. Okay. Also, should note, unilateral mistake is also a misrepresentation. It's a misrepresentation by action. Okay. And then we've got the interesting one of Chi and Digiland More. So it shows mistake is not dead in contract law because somebody on their computer late at night found that the Digiland Mall had made an obvious mistake about the price of the laser printer. Called up all his friends and they tried to take advantage of this. So the company, Digiland Mall, was not very happy about this. They said, hang on, unilateral mistake. And the court said, yes, operative unilateral mistake. And so all of those contracts were rendered void. Okay, good. All right, but remember, mistake is more should know, certainly not must know. And then with regard to duress, the only, well, I suppose we should focus also on normal. I mean, are you under duress? Duress simply means threat of physical force. And of course, if there's a threat of physical force, the other party is not entering into a contract voluntarily. Okay, so duress renders a contract voidable at the option of the innocent party. Okay, and the most relevant type of duress now is economic duress, where one party places illegitimate pressure on the other party. And how do you know whether the pressure is legitimate or illegitimate? Well, the court will say, well, there have to be these three elements: a threat to do something unlawful, such as being in breach of contract, plus no practical alternative for the other party but to agree, and this is really the key element the courts have been emphasizing more recently, there must be protest by the victim. And remember, we came across economic duress when we dealt with Williams and Roffey. Remember Williams and Roffey? Very controversial case which says there is consideration for performing your existing contractual duty provided those elements in Williams and Roffey are found and provided there is no economic duress exerted on the promisor. Okay, so economic duress, the leading case is Powon and Lau Yu Long, PC, personal computer, police constable, politically correct, no, Privy Council. So PC, Privy Council, of course, that was the Court of Final Appeal before the handover. And I was just walking past the Court of Final Appeal tonight, and somebody said, what's that, Bill? It's Court of Final Appeal. Did you know before the handover, the Court of Final Appeal in Hong Kong was in England? You had to pack your bags, fly to England, because the Privy Council was basically the House of Lords wearing a different hat. So there you are. So Powon and Lau Yu Long went all the way to the Court of Final Appeal before the handover, the Privy Council. And so Powon gives us those elements of economic duress. And remember, this element of protest seems to be very important these days. Okay, so economic duress by way of revision, undue influence. We need to spend a little bit more time on undue influence. Remember, in the course manual, they lump duress and undue influence together. I think that's a mistake because they are different. Undue influence duress is a doctrine at law, a legal doctrine. Undue influence is a doctrine in equity. So it does remind us, everybody, be aware of the distinction between being at law and inequity. Okay, now because we're in equity with undue influence, the courts, if you like, the maxims of equity apply. And so delay defeats equity, for example. He who seeks equity must do equity, the clean hands doctrine. And undue influence is similar to duress, but it is improper pressure. There's no real definition of undue influence, but you could describe it as more subtle form of pressure put on on the weaker party to enter into a contract with the stronger party. Okay, so it focuses on the relationship between the parties to a contract. One party is the dominant party and the other party is the weaker party. Okay, and so again, it sort of comes from the general principle that a contract should be entered into voluntarily. And if you exert undue influence on somebody to enter into a contract, that will render it voidable at the option of the weaker party. Okay, and remember there are two different types of undue influence: actual undue influence, and the big difference between actual undue influence and the other type, presumed undue influence, is actual undue influence puts the burden of proof smack on the weaker party, and it's difficult to prove actual undue influence because you've got to prove that undue influence was actually exerted on you by the stronger party. And that may be difficult to do in practice. In the Aboudi case, the court found that there was undue influence exerted on the young lady. And Aboudi, I'm just checking my notes, page 125 of the course manual for Aboudi. So, I mean, the facts look pretty clear, isn't it? And in Aboudi, she was 20 years younger than her husband, okay, and she had married him when she was only 17. So who's the stronger party? Certainly when it comes to financial matters, well, in this case, you would think the husband, right? I'm not saying that ladies are weak. I mean, I bet she had a big advantage over him in other areas of life. But anyway, when it comes to money, you'd think the husband was the stronger party. And she had signed documents relating to her husband's business. She probably didn't even know what his business was. And she was nominally a director, but that's about it. And she signed all of these documents, and including guarantees and charges. And she claimed that charges relating to the matrimonial home, okay, in order to secure loans. Now, of course, what happens in these situations is that the stronger party gets money, because money is lent by a bank, and then the stronger party then loses the money. They go to Macau and gamble or whatever, and so it's the weaker party who says, hang on, I didn't enter into this contract voluntarily. And so this is where the weaker party might take action for undue influence. So in Aboudi, she was able to establish undue influence, but for one thing, the law as it stood in Aboudi did say that the transaction she entered into must be to her, quote, manifest disadvantage. Now, what does that mean? Well, it means that, there's nothing in it for you. You've got everything to lose and nothing to gain. But on the facts, she didn't really have any manifest disadvantage because she was married to a husband. And so, if you like, she had the benefit of, helping out her husband. And this requirement of manifest disadvantage is now gone, because in the later House of Lords case of Pitt, the court said that there's no requirement to show manifest disadvantage. So that's actual undue influence. Hard to prove. That's the point about actual undue influence. And so there is this other type of undue influence is much more important. And when we say presumed undue influence, it's presumed with regard to burden of proof. And remember, there are two classes the courts apply, Class 2A and 2B. Class 2A are the special relationships, doctor-patient, solicitor-client, parent-child. And in those relationships, you can establish that relationship, then the presumption automatically arises that there is undue influence. In Class 2B, the other relationships, you have to establish first that there is a relationship of trust and confidence in the stronger party, plus a transaction that calls for an explanation. Calls for an explanation, why did you enter into it? Not explained by the ordinary motives of ordinary people. That's what calls for an explanation means. I remember one of you asking me what that meant last time, okay? Now, if you can establish those two elements in Class 2B, does that mean there's undue influence? Not necessarily, okay? It just means that the presumption arises, but the presumption can be rebutted. And how do you rebut the presumption? By making sure that the weaker party has been given independent legal advice, ILA, okay? So what's on the screen? Quite a good PowerPoint there on presumed undue influence. And remember, if there is presumed undue influence, if it's proven, then that renders a contract voidable at the option of the innocent or weaker party. Okay, and then the leading case on undue influence is the Ettridge case, Royal Bank of Scotland and Ettridge, House of Lords, in which the House of Lords reviewed all the law on undue influence. So it was quite a major decision, quite a major judgment in Ettridge, and particularly in this area of presumed undue influence, okay, and particularly this Class 2B, in which one party reposes trust and confidence in the other party, coupled with the transaction that calls for an explanation. And again, I've got that on the screen. It means not explained by the ordinary motives of ordinary people. Why? Because you've got everything to lose and nothing to gain. Okay, so that raises the presumption. Doesn't mean there is undue influence, because it can be rebutted, and the normal way to rebut that presumption is to make sure the weaker party has independent legal advice. Okay, undue influence in Hong Kong follows very closely the law in England, because the leading case of Lee Sao Ying featured Lord Scott, who gave the leading judgment, and Lord Scott, no pajamas, non-permanent judge. He was on the House of Lords who decided Ettridge. And in Lee Sao Ying, it was a Class 2B situation. So did the presumption arise? Well, was there a relationship of trust and confidence? Yes, but there was no transaction calling for an explanation. So in Lee Sao Ying, the presumption didn't even arise. And in the Bank of China and Wong King Sing case, again, a Class 2B case, was there a relationship of trust and confidence? Not at all. So in both the cases on the screen, the Hong Kong cases on the screen, both Class 2B cases, and the presumption didn't even arise, okay, which is a bit of a shame. It'd be nice to have a case which won, okay. You might want to add a little bit of a note to this PowerPoint to say, please note they're both Class 2B cases. Oh, I don't want to, I could change it on the screen now, but if I do that, I might upset the whole computer. I don't know. All right, so yes, both Lee Sao Ying and Wong King Sing are Class 2B cases. So the person alleging undue influence had to prove that they reposed trust and confidence in the other party, succeeded in Lee Sao Ying, but not in Wong King Sing, and then called for entered into a transaction calling for an explanation. and neither party was able to prove that second requirement. So in both cases, the claim for undue influence failed. Okay. Undue influence and third parties, probably more should know than must know, everybody, but it's very important in practice. It's where a stronger party exerts undue influence on a weaker party to enter into a contract, normally with the bank. Okay, and so the issue is going to be, is the bank affected by any wrongdoing exerted on the weaker party? And that boils down to whether the bank has notice of any wrongdoing. When I say wrongdoing, it means undue influence, yes, but it could also mean misrepresentation or duress. Okay, some of the cases involve misrepresentation, but the principles are the same. Is the bank affected by any wrongdoing exerted on the weaker party? And the answer is, does the bank have notice of the wrongdoing? And remember, we are in equity. And so notice is very important when it comes to equitable issues. And there are three types of notice: actual notice, you know, or imputed notice, which is through an agent, or constructive notice. Constructive notice, a little bit more difficult. What do you mean by constructive notice? Well, it means that the bank was put on inquiry that there might be undue influence, and the bank didn't take reasonable or proper follow-up steps. How do you know whether the bank is put on inquiry? Ettrick says you're put on inquiry anytime the transaction is non-commercial. So any domestic transaction, the bank should be put on inquiry. And of course, you say, well, can the bank go and ask the weaker party, were you put under pressure to enter into this contract? You're getting into the area of invasion of privacy, aren't you? You can't ask a wife, hello, are you still married? Are you still living with your husband? Are you sleeping together, etc.? So the bank can't ask these very personal questions. So how do they know? Well, if they're put on inquiry, then they need to take reasonable steps to follow up. The reasonable steps basically are to make sure that the weaker party gets independent legal advice. Advise the innocent or weaker party face-to-face, hello dear, go and get independent legal advice. And then you should provide necessary financial information to that solicitor. Inform the solicitor if there are any suspicions about the transaction, and then the solicitor should follow up with written advice that the weaker party, the innocent party, IP, has had the contract explained to him or her. And that will protect the bank. If you like, it's the bank's umbrella. So if the bank's not sure whether it's been raining, so to speak, undue influence, well, take your umbrella. And if it's raining, put up your umbrella or use your umbrella. If there is no rain, if there is no undue influence, fine. But if you're not sure, always better to bring your umbrella. It hasn't rained in Hong Kong for a long time, hasn't it? So I remember I've still got an umbrella. Anyway, and in practice, so this is very important in practice. The Hong Kong Law Society has incorporated the Ettrick guidelines for solicitors who are representing banks. Remember, the banks lend money. The banks are the mortgagees. The people who borrow the money are the mortgagors. Okay, mortgage literally means dead pledge. G-A-G-E means pledge. Who gives the pledge? The borrower gives the pledge. And what do they pledge? They promise to put up their property as security for the loan. So the bank receives the pledge, receives the gauge, and so the bank is the mortgagee. Okay, so there you are. So that's a review of undue influence. Everybody, what are the important points about undue influence? It's a doctrine in equity, number one. It is improper pressure exerted on the weaker party. It's a more subtle form of pressure than duress. Okay? No definition of undue influence, but if you are alleging undue influence, remember there are two types, actual and presumed. Actual undue influence, very difficult to prove, and the burden of proof is on the person alleging undue influence. The much more important form of undue influence is presumed undue influence. And remember the two classes, Class 2A and 2B. And Class 2A, the presumption automatically arises. Class 2B, the person alleging undue influence has to establish those two elements of reposing trust and confidence in the stronger party, coupled with a transaction that calls for an explanation. And if you can establish those two elements, the presumption of undue influence arises. But remember, the presumption can be rebutted, and the normal way of doing that is to make sure the weaker party has independent legal advice. Okay, good. Now, illegality, I promise I'll go through this, but very, very quickly. Illegality covers a lot of pages in your course manual, and all of it, basically, everybody might like to know, not even should know. And illegality covers a wide range of situations. It can be where a contract is illegal at formation, or it can be illegal in performance because it's against public policy or legislation. If the contract is legal at formation, it renders the contract void from the very beginning. So that's worth noting, I suppose. And there's an interesting case, I suppose it's interesting, interesting case of Pearce and Brooks. And Pearce and Brooks is on page 134 of your course manual. Make a note, 134 of the course manual. I mean, the facts are sort of interesting. The plaintiff was a coach builder who hired out an ornamental carriage. An ornamental carriage, mind boggles, to the defendant, who was a prostitute. I mean, you're all adults, you know what I'm talking about. The plaintiff knew that the defendant was to use the carriage to attract her customers. I mean, it's a bit like a spider attracting... So when the defendant returned the carriage, lo and behold, it was damaged. Oh my goodness, I wonder why. It must have been rather physical. The defendant also failed to settle the hiring fees after the second installment. So the coach builder sued the lady, and she said, no, illegality, and won the case. The contract was void from the very beginning. That's probably the only interesting case on illegality. So if it's illegal at formation, the contract's void from the very beginning. If it's illegal in performance, the results vary according to the facts of each case. That's all you can say. Now, I'll leave it up to you. You can read all of those cases, which are all sort of interesting. But frankly, everybody, you're not going to be examined on illegality in the exam. So if you're interested, by all means, go and read it. But it's certainly not must know. I don't think it's even should know. Well, maybe should know. Probably more like might like to know. Okay, so that's illegality, dealt with rather quickly because that's it. We need to spend much more time, though, on unconscionability. So what is unconscionability? Well, it's a very long word, absolutely. Okay, is there a definition? No, there is not. Okay. Unconscionability, the law on unconscionability is largely in the Unconscionable Contracts Ordinance. And we're going to go through the UCO in a little bit of detail. I've got the section numbers, the important section numbers on the screen. So the UCO is a layer of legislation that is designed to protect consumers. And we've already looked at, when we dealt with exemption clauses, consumers do get a fair bit of protection from the law. Remember, we've got the Control of Exemption Clauses Ordinance, which protects consumers. And by the way, you know what an exemption clause is, don't you? Check your definitions. A term in a contract which seeks to exclude or restrict liability for either misrepresentation, negligence, or breach of contract. Okay, but for some reason, the Hong Kong Ledge Code decided to enact the UCO back in 1995, but it's fairly limited in its application. It covers contracts for sale of goods and supply of services, good, but it doesn't cover other areas of law, which a lot of people thought it should, in particular, contracts relating to land, okay? And this is seen to be a deficiency in the UCO because, I mean, lots of people sign tenancy agreements or leases in Hong Kong. And if you look at a tenancy agreement or a lease, it's a very one-sided document. You will find it says tenant agrees, A, B, C, D, right up to Z, and then double A, double B, double C. How many is that? 29 obligations, roughly, put on the tenant. And then the landlord agrees, A, B, C. So you can see a tenancy agreement or a lease is a very lopsided document, heavily weighted against the tenant. And so people thought, well, why doesn't the UCO cover contracts relating to land? Good question. So that's one of the criticisms of the UCO. Okay, so bear that in mind. And because the UCO only covers contracts for sale of goods and provision of services, there is another area of law relating to unconscionability, that is common law unconscionability, in other words, case law. And that will apply when you have a contract other than the sale of goods or provision of services. Okay, so let's have a look at the UCO first. And this is the reverse of order that's in your course manual. So I'm on page 157. The UCO does note is of limited application in the context of consumers, does not replace the principles of equity. In other words, that's the unconscionable basis. All right, but let's have a look at section 3. It does cover consumer contracts for sale of goods, provisions of services, but not land. That's or not sale of land or contracts dealing with land. What do you mean by unconscionable? How does the court decide whether a contract is unconscionable? Well, there is no definition, but the courts will look at various factors, and these factors, everybody, are quite familiar to us. The strength of the bargaining positions. Remember when we dealt with exemption clauses, remember the legislation under the CECO will render an exemption clause either totally void or make it to the subject to the test of reasonableness. And the test of reasonableness, one of the major factors that the court will look at is the relative strength of the bargaining power of the parties. And is there inequality of bargaining power? Okay, so there's a bit of overlap here because this is an element that would be considered under the CECO when deciding the reasonableness test. Also, there you are, undue influence. The court will look to see whether there's any undue influence exerted on one of the parties. And of course, we've just covered undue influence. And of course, other general factors, whether the consumer understood the terms, which means, by the way, we're in Hong Kong. Were the terms put out in both English and Chinese? So that, you know, Hong Kong is a bilingual society, so all notices in Hong Kong are supposed to be in English and Chinese. And so same here, did the consumer understand the terms? Was it in the right language? And of course, was the language understandable? And of course, other factors, you know, did the consumer have alternatives? Could they have gone to somebody else? Okay. So they are the factors the court will take into account under Section 6. And then Section 5 outlines the possible orders that the courts can make. And the orders can vary from refusing to enforce the whole contract, basically saying that the contract is void, or they can revise or limit the application of the contract. In other words, they can if there's an offending clause or term, they can simply take that out of the contract, delete it. Okay. So I would say sections 3, 6, and 5 must know. Remember, section 3, you can criticize section 3 because it's not broad enough. It should have covered contracts relating to land. Section 6 just gives us the factors the court will take into account in deciding whether there is unconscionable behavior. And section 5 comes up with the possible orders that the court can make. And yes, if you can remember, and your examination, by the way, is closed book, so I shouldn't be loaning you too much with legislation, but I would say if you can remember 3, 6, and 5, good. Okay. Now, what about cases on this? Well, we have one very interesting case, and this is the Hang Seng credit card case. And whenever you're dealing with unconscionability, everybody, this is your case. And it's quite an interesting case. Your course manual covers it reasonably well, but I think they get a couple of points not exactly right. So let's go through the Hang Seng credit card case. Now, I'm not sure how many of you have a credit card, but if you haven't got a credit card, you're likely to get it. Okay, so what happened in this case, there was a customer who was behind in his payments on his credit card, and he was sued by the bank. Okay, well, the bank's entitled to sue you if you don't pay up. And I'm not sure what the numbers were here, but let's say he owed something like 20,000 Hong Kong dollars. The bank took action to sue him, and the sum claim was $20,000, yes, plus legal costs. And the big complaint of the customer here was that the legal costs were huge. They were at the highest indemnity rate available. And so the customer was not happy. So who do you complain to? The Consumer Council. And the Consumer Council then sent it, I think initially to the Small Claims Tribunal, but then it was kicked upstairs to the Court of First Instance before Mr. Justice Yam. Now, Mr. Justice Yam, very lovely case. I appeared before him, very nice man. And he had a look at this case, and it was decided under the UCO in the year 2000, so just a few years after the legislation came into effect. So was this clause in the consumer credit card contract unconscionable? Okay, and the judge says it was unconscionable. Now, what were the factors? Well, there was inequality of bargaining power. Yes, good. There was a pretty high interest rate, 59%, but that wasn't critical. In fact, that wasn't illegal because there is a money lenders ordinance in Hong Kong, which means a money lender can't charge more than 60% per year. But the money lenders ordinance doesn't apply to banks. So you couldn't argue that this was against the money lenders ordinance. Still pretty high. Was this a factor? The court said yes, but not a critical factor. The main reason why the courts found that this particular clause was unconscionable is that the question of costs is wholly and solely at the court's discretion only. You can't decide who pays costs and how much in a contract. The question of costs is solely in the jurisdiction of the courts. And that's the main reason why the judge found that this particular clause was unconscionable. Okay, so your course manual doesn't really mention that too much. It mentions the rate, it mentions the inequality of bargaining power. It doesn't really mention the fact that the question of cost is solely at the court's discretion. And so what happened was that the judge made an order, the order under Section 5, and the order was to amend the wording of that particular clause in the credit card agreement so that the bank couldn't charge sort of, unlimited costs. Okay, all you could say is that if the bank was going to sue a customer, the customer would have to pay the principal plus costs. That's all you could say. You couldn't say what the rate of the costs would be. Again, but you couldn't even say, well, usually you could say it would be cost, but costs is who pays costs and how much is really a question for the courts to decide. So the wording had to be changed. So if you got a magnifying glass, go and look at your credit card agreement see if you can check the relevant clause. You'll find that the wording has changed, and so the banks can't charge you the highest rate for legal costs if they're going to sue you. Okay, remember in this case, the bank definitely had a cause of action. The customer was behind, so the bank was quite entitled to sue him. Fine, but the courts found that that clause dealing with costs was unconscionable. Okay, and this particular case is the first significant case on the UCO. So there you are, must-know case. It was a test case, and it applies to all banks. So you don't have to be a Hang Seng Bank customer. It applies to all banks. Okay. Actually, when this case was decided, I was actually the in-house lawyer at Citibank. I remember I got interested in this particular case because it was a test case. And then one thing to note, slightly odd, remember the UCO is supposed to be there to protect consumers. So why is the burden of proof on the customer? Because that's what Section 5 sub 2 says. So you can criticize the UCO if it's supposed to be in favor of the consumer. How come the consumer still has the burden of proof? Okay, so the UCO, useful piece of legislation, but you can criticize it for not covering contracts relating to land. You can criticize it because it's still got the burden of proof on the customer. Okay, so that's the UCO, the Unconscionable Contracts Ordinance. Okay, now before we go up to the break, let's sort of go backwards slightly in your course manual anyway, and have a look at what you might call common law unconscionability. Okay, and we're talking about unconscionability. It is a doctrine in equity. So when we're talking about this expression, common law means case law. Okay, so because the UCO is limited to contracts for sale of goods and provision of services, the common law still applies, and it applies to other types of contracts. So the cases which are in your course manual, most of them deal with contracts relating to land. Okay, so it is possible to succeed in an action for unconscionability at common law, but circumstances in which the principle applies are very limited. It's rarely where one party takes unfair advantage of their superior bargaining power against somebody who's either ignorant or handicapped in one way or another. Okay, it's very difficult then to prove common law unconscionability. Okay, it's really where the weaker party is sort of suffering some sort of illness or weakness. Okay, and the burden of proof is obviously pretty hard to discharge as well, because if you're alleging unconscionability, he who asserts must prove. It's difficult to prove unconscionability. Now, you've got two cases in your course manual on page 157, Ming and Ming, and the other one is Tong and Tong. Okay, I haven't got Tong on my PowerPoint. You'll notice in both those cases, the court found there was no unconscionability. Okay, so you can read through those cases for yourself in Ming and Ming. It's actually a court of final appeal decision from fairly recently. The court said it's very difficult to prove unconscionability at common law, and in that case, Ming and Ming, no evidence of unconscionable dealings in respect of documents signed by a father, or that he was under any special disability that might have affected his judgment. Okay, so Ming and Ming, the claim for unconscionability failed. Also in Tong and Tong, you've got the facts there. It was about sale of a property, seemed to be at some sort of undervalue. The court found, well, it was not an unconscionable bargain as the property was sold at an undervalued amount. Said, well, seems slightly odd, but you have to be really, to be unconscionable, have to be way undervalued. It was slightly undervalued, but not way undervalued. And then a case that's not in your course manual, which I think is an interesting one, but I've got it on my PowerPoint, is a case of Low and Churn. If you want to check on Low and Chung, it's in my contract law book. But the facts are interesting, and the other interesting thing about Low and Chung is that the claim for unconscionability at common law did succeed. The plaintiffs were two elderly sisters. The defendant was a Hong Kong property developer. Ta-da! Okay. And what happened is that the property developer had sold property, okay, and they were selling this particular property. Half the share was held by the sisters, the other half was held by somebody else. The half held by somebody else, by the property developer, was sold for $2.4 million. Half was sold for $2.4 million, but the half share sold by the sisters yielded only 870,000 Hong Kong dollars. And the sisters did not know that the other half had been sold for what, more than 3 times the amount that they got. Well, is it 3 times? No, well, almost three times. Okay, so remember, this was a claim for unconscionability at common law because the UCO does not apply for contracts for the sale of land. And so on the facts of this case, the court found that there was unconscionability because the property developer had an unfair advantage, and they had taken advantage of the sisters' ignorance. The sisters did not know that the other half share had been sold for $2.4 million, and so they found out later. So when their half was sold for only $870,000, they said, hang on, this is not right. So they got good legal advice, went to court and won the case in 2001 before the Court of Appeal. So well done, sisters. I mean, you know, in Hong Kong, the land is pretty well controlled by the 7 big property developers. So here the property developers lost because they acted unconscionably with regard to the sisters. Okay, so Low and Chung, if your surname is Low or if your surname is Chung, here's your case. Okay, and it's always good to have a case that has your name because that's one case name you should remember. All right, everybody, so that's a common law unconscionability, and that is unconscionability. Probably the more important part, I'd say, must know sections 3, 5, and 6 of the UCO, must know what the UCO covers, contracts for sale of goods, provision of services, and I'd say must know the Hang Seng credit card case. The court found there was unconscionability there. One reason, unequal bargaining power. Another reason, high interest rate, but that wasn't sufficient. Those two factors were not sufficient to establish unconscionability. The main reason was that the question of costs was not to be decided by the bank. The question of costs is solely in the domain of the court. The court decides who pays costs and how much. Okay, so a good decision by Mr. Justice Yan, the Hang Seng credit card case. Probably the leading case on the UCO. Okay, I mean, but also you can criticize the UCO. Why does it not apply to contracts relating to land? And why is the burden of proof put on the customer under Section 5, Sub 2? I mean, the UCO is better than nothing, but everybody thinks perhaps it could have gone a little bit further in providing protection for you and me, the consumer. Okay, everybody, so that's it for the vitiating elements. What I want to do, everybody, I've got some assignment notes which I'll talk to you about after the break. So perhaps some of you could tell me, can you tell me what is the deadline for submitting your assignment? And also just give me the first sentence perhaps of the first question. If you do that, I know what the assignment's all about and I know what your deadline is. And then I want to talk about these points which are on the screen with regard to the assignment. Okay, so I think though it's a good time to have our break now. So we'll have our 10-minute break. After the break, I'll talk about the assignment and then we'll get on to termination of a contract. Okay, welcome back, everybody. Hope you had a good hot drink. I had some lovely hot chocolate from Starbucks just down around the corner there. Okay, so before the break, I said I'll talk to you about the assignment. I'm not sure when your assignment is due, because I've lost track of the dates. But anyway, perhaps, here you go, 23rd of March. Where are we? Yeah, so you've got, okay, but there are two questions. One is on contract law. The other one's on tort law. Okay, so we'll cover all the material, no problem with that. I think the first question is on formation of a contract. Okay. Leave the message. Morning, buy the car for that. This morning. You've seen an email. Not had a chance reading. I'm just, yes, okay. So it looks like it's the one on, well, we'll go through the, the principles we covered in the first one or two lectures. Remember, with regard to formation of a contract, the court will look for essential elements in the formation of a contract. That's how you start off your answer, okay?